Last Ciarán Comhairle, and I think it's not unreasonable for Deputy O'D to bring forward this bill in order that we can have a debate on this issue. It is largely, apart from the one or perhaps two issues that appear in this current bill, largely what we debated before in the context of the Industrial Relations Amendment Bill 2009, a bill which I should say to the House that I supported and spoke in favour of in the Senate. And I think that it is true what Deputy O'D says, that it was an attempt at the time to anticipate the likely frailty and the ultimate fate, I think, of a challenge that was then being brought to the orders and to the JLC system. I would say, though, to Deputy O'D, through you, I'll ask Ciarán Comhairle, that the notion of the government appealing the decision of Judge Feeney to the Supreme Court as a tactic, I understand where Deputy O'D is coming from, but that approach, as he will appreciate, is fraught with danger, particularly for a government, simply to appeal to the Supreme Court as a tactic. I mean, in circumstances where Deputy O'D has himself said that he would regard the prospect of success, if I heard him correctly, as minuscule, you know, it would be wrong for the House to have the impression, though, that to bring forward such an appeal to the Supreme Court would automatically would mean that the government would automatically obtain a stay on the orders. That is certainly not the case at all, that such a stay would necessarily result from the bringing of an appeal. And in fact, I would have thought myself that that it would be very difficult to obtain a stay in the context of the particular decision that's been made by the High Court. I say it's not unreasonable for, I think, the Deputy to bring forward this bill, but I think it is right, the government is right and the Minister is correct in the approach that he's taken, as is the Taoiseach, in saying that the bill isn't sufficiently robust. The Minister is correct. There are a number of things that need to be done in relation to this legislation, and necessary, vital improvements in the legislation in order for it to be fit for purpose and to achieve the job that everybody wants it to achieve. One of those is that we can't forget that there were two really essential pillars in the Feeney judgment. One was the absence of principles and policies to guide the court and the JLCs, but the other was the very real issue signalled in that judgment in relation to property rights and in relation to the property rights and constitution, as to whether they were offended by this system. And I would have thought, Ciarán Comhairle, that at the very minimum, the government, prudent government, and indeed this House, would want to proof the legislation in the context of that particular issue of property rights. And when we've seen, you know, protective legislation, trade union legislation, proposals for trade union legislation in the past coming a cropper on this area of property rights, it's a huge problem for those of us who want to see real reform and indeed full collective bargaining rights for trade unions. A huge problem. And I think it's a problem here as well. And I would think it would be most imprudent to rush legislation in circumstances where the High Court had also said there's an issue in relation to property rights to be dealt with. Maybe it can't be dealt with in legislation. I mean, they're of the nature, those sort of rights of the nature, that's very hard to deal with purely in legislation, but certainly we would need to do that. The other issue is, of course, the one that the Minister has referred to, Minister Sherlock, and I suppose my colleague Deputy Mitchell as well, is the principles and policies issue in that judgment. I mean, the Minister has signalled an intention to bring forward reforms. The government is committed to reforming the JLC system. There was consultation and some debate and discussion as to how that might be achieved and what precisely those changes would be. I would expect that agreement could be reached on that agenda, but it seems to me that the principles and policies that would then result from that agreement should be incorporated in any new legislation. So the principles and policies that Deputy O'D has in his bill, which come from 2009, which are the interests of the workers, the interests of the employers and so on, somewhat bland. They cover a bit of ground, but not all the ground. We should use the legislation to provide for those new principles and policies as well. But can I say this? And I think there's two crucial things I want to say about the bill, about the bringing forward of this bill, which I don't criticise the Deputy for, but I ask him to consider this and the House to consider this. It is not true to say that were this bill to be passed tonight, even, all stages tonight, that this would immediately bring about a change. Because as Deputy O'D must know, you have a procedure in the 1946 Act where you set up JLCs on the basis that a JLC would have to be set up again, if it has to be set up, is an absolute minimum of 30 days. In fact, you would have to have your 24 hours work, do all the bureaucratic work, then there's a 30-day period for an inquiry to be held as to whether a JLC should be set up. Then when you go forward to actually making an employment regulation order, having set up the JLC, there's another 30-day minimum incorporated in there. There's a 60-day period that will result from the moment that this legislation would be passed if it were passed. Meanwhile, we have the break in August. We can come back in here in the middle of September, which is a lesser period than the 60 days. The Minister can work ahead with the Attorney General, bring in legislation that would work. Legislation, by the way, when we were taunted somewhat by Deputy O'D and his colleague Deputy Collins, what's the Labour Party doing and what do we stand for? We stand for legislation in this area that will work. Not just giving the impression to the 200,000 people that we're all in here to defend and support, not giving the impression to them that we could do something by a piece of legislation which could end up actually being faulty. So let's do it right. Let's not be pretending that this is emergency legislation which, if we pass it, can sort everything out in a day. It can't, it won't. That's simply the reality of it. And the very final thing, Ciarán Comhairle, if you could indulge me in this, that there is another significant flaw, I have to say, to Deputy O'D in his proposal to decriminalise the breaches of the orders. And not that he's wrong in seeking to do so, but in fact he doesn't replace it with a proper civil enforcement mechanism at all. Because he says an order would be made by the Labour Court, but again, as Deputy O'D be aware, an order of the Labour Court unfortunately stands for very little. It's not enforceable in the courts. And what we've done in employment legislation for 20 years is we've allowed people to actually get their Labour Court order and bring it into the Circuit Court and have it transformed into an order, a court order, so they can then have it enforced against their employer. A Labour Court order on its own is, I'm not going to disrespect the Labour Court by saying it's not worth the paper it's written on. Of course it's important, it's an order, but it's not enforceable. So the actual proposal in the bill to decriminalise doesn't in fact replace the thing with a properly enforceable mechanism at all. So clearly the bill has to be looked at, and I support the Minister in what he intends to do.
Thank you, Deputy.